Thank you, Mr. Chief Justice, and may it please the court. Let me just start by picking up on questions about what the inquiry is that the BIA is making here and what our position is on what the standard is here. So the courts of appeals have broadly agreed that persecution means really extreme suffering. So you kind of plug that in, kind of like the court did in US Bank. So what the agency is asking here is, looking at the evidence that the petitioner has provided, is this extreme suffering? How much suffering has there been? And that is a question that requires lots of weighing of facts and drawing of inferences. So in this particular case, just look at the facts here. So on the one hand, petitioner's half-brothers were shot because of a dispute between their father and the half-brother's father and a Sicario. But then on the other hand, his mother and his stepsister and his stepfather were never threatened or harmed. The half-brothers appear to have been fine when they moved away from the hometown. Petitioner appears to have been fine when he moved away from the hometown and he lived for years in peace in other parts of El Salvador. And then petitioner talks about the threats, but on the other hand, the threats demanded money. So what do you infer from that? Was it just intimidation? Were they even connected with the Sicario? I mean, these are all questions of the kind that go to juries. The juries draw inferences. They can cut in different directions. You have to weigh the facts and inferences. What we're saying here is Congress wanted substantial evidence review to apply so that there is deferential review of that weighing of facts and inferences by the agency. And we think it's very clear for several reasons. Let me just do 3 quick points. One, we think the text and the history point exactly in that direction. So one, Congress in Section 1158 talked about the question as one that is factual for the trier of fact. 2, this court and Elias Zacharias beforehand had said that that was a factual question and applied substantial evidence review. The courts of appeals had all done that. And then the substantial evidence provision at issue here codified language from Elias Zacharias. So clearly Congress was aware of it. There's no way, no realistic chance that when Congress was overhauling standards of review in IRIRA and affirmatively overturning what courts of appeals were doing in certain respects, and then codifying Elias Zacharias, that he was either unaware of that practice or silently departing from it. It's just not realistically possible. And the second point, I'll do even more quickly, this court's standard approach, even if you thought the statute were less clear, the standard approach that the court uses across a variety of contexts points in exactly the same way. The work being done here is primarily factual, and just last year in Wilkinson, this court applied that approach to the INA and said that application of extraordinary hardship is going to be a primarily factual inquiry that is subject to deferential review. And the last thing I'll say is petitioners' contrary arguments, they really kind of all boil down to the idea that every mixed question in the INA is going to be subject to de novo review. I think this court, both in Guerrero-Lasprilla and Wilkinson, said that wasn't going to be the consequence. And I think that would be a sea change and irreconcilable with IRIRA. I welcome it.
Thank you, counsel. I'm sorry.
No, that's go.
Your friend began the argument by saying there were not, in fact, factual determinations. What precise facts do you think would be necessary to resolve?
So I think here the ultimate fact is the one that's at issue, is how much suffering was there? So, for example, I'll point the court to the decision in TSC Industries about materiality. There are all kinds of situations in which juries get a question like, was the statement material, or pain and suffering, or negligence? And you have historical facts that could be undisputed, like here there were these threats, and we know what was said. But then what do you infer from that? How much suffering was there? How do you balance the fact that he was fine when he moved away from his hometown versus the fact that he was threatened several times and the threateners asked for money? And that kind of weighing is one for the BIA. Now, if petitioner succeeds in the argument that no reasonable fact finder, no matter how you weigh the evidence against him, no matter what inferences you draw against him, no reasonable fact finder could have found that there was no persecution, then he would win under substantial
evidence. Isn't that a legal question?
That question, when you draw all of the inferences, yeah. And that's what we say should be done.
So that's a legal question that judges can review under that pre-existing standard that Elias Zacharias speaks of.
That's correct, and that is our position.
And also you concede on page 40, as Justice Kavanaugh pointed out, that if there's some dispute about what the term persecution means as a matter of law, that a court can resolve that de novo.
Yes, that's right. And just to pick up on Justice Kavanaugh's earlier question about how that
You hear the difference in tone from the justices in their questioning of the Trump lawyer versus their questioning of the migrant lawyer. This could be an I-know decision for Trump.
would work. I think this is very similar to what courts of appeals do in all kinds of contexts, and in fact, what they are doing under the INA. So think of the example of a district court. There are all kinds of decisions that district courts make that are subject to abusive discretion review or clear error. And all the time, litigants come and they say, okay, so here are my arguments on abusive discretion and clear error. But setting aside the way that the district court cashed out my particular facts, the district court used the wrong standard. And that is a legal question, and you have to correct the legal standard de novo. And the courts of appeals distinguish those things all the time.
Would I be right, Mr. Dos Santos, to say that I could say the same of your position that you just said to Mr. Rossellini? You said he would have every mixed question turn into a de novo question, but would you have every mixed question be given substantial evidence review?
No, Your Honor, I think you could look at the way that this court talked about it in U.S. Bank. Not all mixed questions are alike.
So what kinds of mixed questions would not get substantial evidence review with respect to these matters?
With respect to what, I'm sorry?
These matters.
So I don't have any examples to give you in that respect. I think a lot of what is done is going to be factual in the immigration space. If there are legal questions that turn on interpretation of a particular definition, like a reticulated definition, and the primary work being done is interpreting, looking at a statute, looking at structure, looking at legislative history, and so on, which is not what's at issue here. I mean, then it looks more primarily factual. The other thing I'll say is one of our arguments is that Congress treated this as factual. So if there were evidence that Congress treated something else as more legal, then that would cut the other way. But I mean, here, if you look at Section 1158, Congress said—
I don't get that argument, I have to say, Mr. Dos Santos, because it seems you have some good arguments in this case, but honestly, none of them come from the text. You have good history arguments, you have arguments about the Elias Zacharias case, but 1158, just because we call an IJ a trier of fact, you're going to read that to determine what the standard of review is?
So several—
I mean, if you just said that we don't give substantial evidence review to legal questions, if we took your textual arguments seriously, we'd have to give substantial evidence review to legal questions too, because after all, 1158 calls the IJ a trier of fact.
So I think what we're saying about 1158 is the thrust of the way Congress thought about the refugee question, is someone a refugee, is that it's primarily factual. And so the way that it described the way that an applicant sustains the burden, that's the title of the provision, to show that they're a refugee, was by saying that they have to satisfy the trier of fact, not only that their evidence is credible, not only that it's persuasive, but that it's sufficient to show that. And then goes on to say, and the way that the trier of fact does that is by weighing the testimony, weighing the other evidence. And that combined with Congress's codification of Elias Zacharias, taking that same language and plugging it into the substantial evidence review provision, combined with the history before that, I mean, I think it all just makes clear that the way Congress was thinking about it is these are primarily factual inquiries that the IJ is going to make, that we want to have the Attorney General take care of. And then—
Did you say at the beginning that extreme suffering is the essential standard here?
Yes, I think every court of appeals essentially has said persecution—
Is that a legal question, what extreme suffering means?
No, I think that's the kind of inquiry that's going to just, you look at the totality of the circumstances. I think it's kind of a concept that most people can grasp, and you're going to have to, in each case, just look at all of the facts and say, was this extreme enough? How much suffering was there here?
But I think that suggests that you really can never have cases that serve as precedents for others, or that the court is not actually developing law in the area. And that's my concern. I mean, I understand questions of fact that arise out of disputes over what happened. So if we had a situation, not this case, but if in this case there was some question about whether he was actually threatened, the government had some evidence that showed that what this person who was seeking asylum said happened to him wasn't true, all of those things would be questions of fact that the trier of fact would be charged with determining. But then—
It's such an annoying voice. Oh my God. It's so grating. I've shared this story before, but I've watched the Supreme Court oral arguments in person, and whenever Ketanji Jackson starts talking like this, you can see Clarence Thomas, who sits right next to Chief Justice Roberts. He does this thing where he takes his glasses off, his reading glasses off, and he unlatches his chair and he puts his hand on his forehead and he leans his chair way back like this, like he's got the world's worst migraine. And then when she stops talking, he brings himself back up, relatches his chair, puts his glasses back on, and he's all good again. It's such an annoying voice.
And once we have the established body of facts, you move to another stage, which is determining whether or not this body of facts meets a certain legal standard, whether it's persecution or some other standard in this area of the law. There are many legal standards in immigration law. And I guess I'm just concerned about the suggestion that in this second stage where we have settled on the facts and we're deciding whether or not, or the agency has decided whether or not the legal standard is met, that we're somehow now in a world that is not a question of law.
So that's because, like this court has said several times, when there's a mixed question, it's not just the historical facts, it's what inferences you draw from them and how you weigh them. And that's traditionally the province of the jury, like this court said in TSC Industries, where the court said it's not proper to do summary judgment for the materiality question when, even if you take the historical facts, there's going to have to be inferences drawn and weighing. And the other thing I'll say is that it's not the case that the legal principles go totally undeveloped. I think that's totally belied by experience over decades. There are lots of times when courts of appeals in the course of applying substantial evidence review will either say, one, petitioner wins, so as a matter of law, no matter how you weigh this, then you have this rule of law. But also, in the course of saying that, they'll provide broad guideposts. Like, for example, in general, mere threats are usually not going to be enough.
Well, could we develop the law, too, as we do with jury verdicts, and say some set of facts cannot be reasonably, by any fact finder, reach the conclusion of persecution?
That's right. So it's exactly in the same way that you would review a jury verdict.
The law that way.
That's right.
But what about the very limited circumstances that our friends on the other side point out, like fair use doctrine under the copyright statute, that we will review de novo without that kind of gloss?
Yeah, I think the court has said that when the background, I should say, just to back up to sort of make clear what the inquiry is here. In the U.S. Bank, sort of how do we decide which bucket of standard of review to put something in? There are a couple of different important considerations. The lodestar is what kind of work is there, primarily factual or legal? But then there's also, you consider the background, what's the tradition been here, and whether it's constitutional or not. With those kinds of questions, the ones you're referring to, I think the court has looked to, the history of this is that it developed de novo in like a common law sort of way.
Was usually done by judges.
Right, it developed that way. And so if Congress has then talked about it, we presume that Congress was treating it that way. That's not the case with these kinds of determinations. The tradition cuts exactly the opposite way.
I'm a little confused by your answer to Justice Gorsuch. You said what a definition of persecution could be a legal error if that's what they were challenging, correct?
That's right.
All right. So here, if they had said, why do you need to show suffering at all? If it's a death threat, why isn't that standing on its own suffering? The threat itself doesn't cause you suffering or harm. You see your mother or your father killed in front of you. You suffer from their death, but you're not suffering from the threat.
So as petitioner, I think, admitted, they didn't make that argument about the legal standard. So the only question was applying the First Circuit's own precedent.
So in answer to Justice Gorsuch, you then said that it was a legal question of whether any reasonable fact finder would have said this was not prosecution. And you said that's a legal question, correct?
Applying the standard that the circuit had already announced, yes.
Yes. So I think what the other side is saying is the First Circuit, I'm not sure what they're saying, whether they're saying the First Circuit didn't apply that standard at all.
No, the First Circuit definitely applied the standard. Everybody applied that standard from First Circuit cases. The IJ, the BIA, and the First Circuit itself.
No, the standard being that no reasonable fact finder could not find this. Every reasonable fact finder would find this persecution. It's a little easier to put it in the positive rather than the negative.
I think petitioner agrees that the First Circuit applied that rule, which is substantial evidence, which is Elias Zacharias.
Thank you.
Why does the BIA review these kinds of questions de novo?
Yeah, so I think understanding what the regulation actually says, which is different from what my
I'm just
friend...
curious why.
So if I could give you a little background, it'll make more sense.
The underlying rationale is for that.
Yes, I think the history is very helpful here. So before 2002, the BIA was reviewing everything de novo, including facts.
I got the history. I'm just like, what is the reason
that
makes sense?
So
why, like Judge Collins said, why something that's treated as a question of law transforms into a question.
So here's where I was going. It's not that it's a question of law. What the regulation says is we're going to stop the de novo thing. We're going to do clear error for facts, but we don't want that to mean that judgments and questions of discretion are not subject to de novo review. And it said judgments include decisions about whether the applicant has shown past persecution.
That's telling me what the regulation is. I'm still trying to get it.
Yeah,
like,
well, my answer is because it's a question of judgment, and both the BIA and the IJ share the responsibility to
what's
exercise.
the difference between a question of judgment and a question of law?
Because judgment is the question about
in
weighing.
This context.
So the question about weighing facts and determining whether it's persecution is going to involve judgment, and both the BIA and the IJ have expertise in looking at recurring fact patterns and seeing all kinds of different versions of these cases, far more cases than any court of appeals is ever going to see. And as this court recognized in Ming Dahai and Orlando Ventura in many cases, the agency has expertise here to apply to deciding those questions. So the AG decided, we'll do clear error, but I'm going to reserve more review for these judgment questions. That doesn't mean that Congress wanted courts of appeals engaging in that kind of judgment in the first instance. And as was already said and admitted, the way that the BIA engages in review, the way that the AG designs internal review has no bearing on that. For example, the BIA reviews questions of discretion de novo. No one thinks the Court of Appeals should do that. It reviewed facts de novo before 2002. No one thinks the Court of Appeals should be doing that either.
If we repeat what you write in your brief on page 40, you think the lower courts are already doing that? Namely,
Yes, I do. I think they were doing that before IRIRA. I think they're doing that now. I think it's standard practice where if a petitioner says, look, regardless of the way my facts cash out, the BIA stated the wrong standard and used standard that's incorrect. That is a question that courts review de novo.
And to show that the standard is incorrect, again, on extreme suffering, what would you have to say? We think extreme suffering is too high a bar.
So there have been questions that have come up. So like one that happened earlier was, is evidence that there's lots of crime in my country and I'm very likely to be a victim of crime, is that relevant to persecution? And the court said, no, that's not relevant to persecution.
That's legal.
So like, is it ever relevant, right? Is it ever going to be relevant to persecution? Legal question, it's not like, look at the facts in my case, it's like, this is the standard. And there are other questions like that where questions about whether the standard should be lower in certain circumstances and so on. So the other thing I just want to emphasize is that this court in Wilkinson really already talked about this some and cited the US Bank sort of formulation and said, and applied it there and said, application of the term extreme hardship, which is kind of very analogous to the question of extreme suffering, that is going to be something that is primarily factual and reviewed deferentially. I think the petitioner's contrary arguments are really saying the thing that this court was resisting in both Guerrero-Lasprilla and in Wilkinson, which is that every mixed question, no matter how factual it is in the INA, is going to be subjected to de novo review. I mean, that really would be a sea change, and it's really irreconcilable with IRIRA. The other thing that I'll note, as Justice Jackson, you pointed out, I mean, the thrust of IRIRA was Congress was coming in and then overturning things that courts of appeals were doing. I don't think there's any realistic chance that you could look at IRIRA and think that Congress was silently departing from the substantial evidence review consensus for persecution questions and asylum eligibility generally in adopting IRIRA, unless there are any further questions.
Mrs. Thomas? Thank you, counsel.
That was short.
Mr. Rossellini, rebuttal?
Thank you, Mr. Chief Justice. Just
We got about
a few points.
5 minutes left.
The first one is that our position is not that every mixed question in the immigration context would be reviewed de novo. Under the text of the statute, our argument is only that mixed questions that resemble the determinations at issue in C and D, admission eligibility and entitlement to asylum, would get de novo review, because if the language Congress could have used is right there if they didn't use it. We think that inference is strong as to this particular question, but other things such as equitable tolling and Guerrero-Lasprilla, other kind of docket management determinations, for example, those would be reviewed for abuse of discretion. Of course, if the government came in and tried to say that those are findings of fact, we would again disagree, but we wouldn't dispute that they're entitled to deference, just a different kind. And then if you are looking beyond the text just to U.S. Bank, that analysis is really limited to just this particular mixed question at issue here. And as U.S. Bank, makes clear, the court has to look at each particular mixed question that comes before it and make the call. So that a decision on those grounds would be even narrower. I think it's telling that the government couldn't come up in response to, I believe it was Justice Kagan asked, would any mixed question in this context get de novo review, and they couldn't name one? I think that's because if this one doesn't get it, it's hard to think of an example. Persecution, again, it is a term of art. It's not something that ordinary people understand right off the bat. It's the product of a major international treaty, and we have decades of experience where courts are coming up with the exact kind of auxiliary legal principles that U.S. Bank talked about as a marker of a mixed question that deserves de novo review. Even though it can, yes, some aspects of the decision can be fact intensive, they involve a close look at the record, but courts are also doing what courts do when they analyze this mixed question, and that's what separates this particular mixed question from others. Second, Justice Kavanaugh, to your question about the BIA regulations, the government is trying to couch this determination as a question of judgment versus law. They don't cite anything for that. We have BIA decisions calling it a question of law. But it really doesn't matter, because the fundamental point is that the BIA agrees that it's not a finding of fact, which is the exact language we have in this statute. And the BIA agrees that the IJ's institutional advantages of being closer to the evidence don't justify deference to the IJ on this particular question. So this debate about judgment versus question of law, it's just immaterial. Fourth, on Elias Zacharias and the history, Justice Jackson, your question, if you look at page 12 of our reply and note 2, we cite examples of cases analyzing this exact mixed question that predate era that were reviewed de novo. The case law, as it is now, is a muddle, so I'm not going to pretend that there was some consensus going in our favor, but we don't need to show that. The government's trying to tell you that there was a consensus that was somehow overruled by Congress. That's not the case. And on Elias Zacharias more broadly, we would just reiterate that the actual dispute in that case was about motive. It was about a subjective state of mind, and the decision needs to be read in that context. And if it's read as the government says it is, number one, the government concession doesn't make sense, because Elias Zacharias, if you take a couple lines at face value, says the entire asylum eligibility determination must be reviewed deferentially, but they're admitting that even legal questions, or even some amount of mixed questions about these auxiliary legal principles are reviewed de novo. So that just can't be right. And we think trying to draw that line about where do interesting cases that are creating auxiliary legal principles, where do those end and where do the fact-intensive ones start? You just can't draw that principle line. And this court has never tried to do that when it's analyzed other mixed questions, like in U.S. Bank, like in Google versus Oracle, and other cases. But finally, even if the court does try to draw that line and accept the government's position, it's not the case that courts of appeals are doing what the government says is correct. Some are, but some are not. If you look at page 3 of our reply brief, we cite a 10th Circuit decision and a 4th Circuit decision that said, look, we acknowledge that the BIA has created this legal rule, but the 10th Circuit said we can't disagree with that legal rule unless we can overcome the substantial evidence review. And the 4th Circuit ultimately disagreed with the BIA, but only because it found that this requirement of showing significant actual harm was manifestly contrary to law. So it too was deferring on what even the government admits is a legal question that should be reviewed de novo. So if the court, even if it sides with the government here, we believe that is an important change. It's clarified the standard of review that will matter going forward, and it should matter in this case, and we should be entitled to a vacator of the judgment below, at least on those narrow grounds.
Thank you, counsel. The case is submitted.
All right, that is it, folks. I expect this to go very poorly for the migrant. I think we might see a 9-0 decision here. Maybe Jackson will feel obliged to write some kind of concurrence, but there we go. So again, this is the Supreme Court reaching out and checking an assertion of power by an Article III inferior court, a court of appeals saying, no, you don't have the authority to second guess, assuming they come down this way, which I expect, you don't have the authority to second guess a finding of fact by an immigration court on whether someone has been subject to persecution. And that's good. Any checks in the Supreme Court against the inferior federal courts are a good thing, because they are, as you all should know by now, those inferior courts are new Branca mug, available in the description of today's show, in the shop underneath today's video. They are the unelected, black-robe, tyrannical, inferior federal district trial court judges, both at the district trial court level and the Court of Appeals level, that need to be checked. And if Congress is not going to do it, and so far Congress has not been willing to do it, then we have to rely on the Supreme Court to do it.